It's you. Oh, come on up. Who's your attorney? Mr. Goldman. He stepped out. All right. Well, I'll pass it. Okay. Court does call the case of People versus Reginald Sims.
Quick pause here. This is a conflict waiver moment. Translation? Everyone's officially agreeing there's no bias problem, so nobody can cry unfair judge later if things go sideways. This is courtroom chess, not small talk.
They also stepped out.
Good morning. Okay, I'll pass that one too. Third time's a charm. Court calls the case People versus Chanel Griffin. Miss Pate is here, and I think your client is in Zoom.
Assistant Public Defender, on behalf of Ms. Griffin. Oh, can you please state your name for the record, ma'am?
I'm here.
State your name.
Chanel Griffin.
Thank you, Your Honor. Me and Ms. Griffin had the opportunity to review the PSI. We only have one update. I believe since the report has been written, Ms. Griffin states to me she has taken.
Notice how smoothly this case moves. That's what happens when a defendant fixes outstanding warrants before sentencing. Judges love responsibility. It's the courtroom equivalent of doing your homework early.
Care for outstanding warrants. Outside of that, we have no corrections to the report, and we would respectfully request the court adopt the probation's recommendation for the sentence.
All right. Ms. Griffin, anything you want to tell the court before I impose sentence? Question mark.
Ms. Griffin, was there anything you wanted to say before the judge imposed sentence?
Oh, I'm sorry. No, sir. I didn't. Oh, maybe you guys can't hear me. I'm sorry.
Sentence of the court, $480 fines and costs, 93 days in jail, suspended. When can you pay the fines and costs, ma'am?
I can have it paid off in, I say, like 90 days.
She say 90?
I believe
90.
so, Your Honor.
90?
Yeah.
Like
90
90?
90, yeah.
Well, you're going to have to do it a little bit sooner than that. I'll give you to February 28, 2026.
Okay.
All right. Thank you.
Thank you so much.
Thank you, Your Honor. Thank you, Ms. Griffin.
Thank you.
Court calls the case People versus Ethan Ryans.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Ryans, who appears on Zoom. Sir, please state your full name for the court.
Good morning, Ethan Ryans.
Go ahead.
Thank you, Your Honor. Today's date and time set for sentencing. We have had the opportunity to review both the assessment as well as the recommendation from probation, which I have had the opportunity to review with Mr. Ryans. He does just have one request as to the sentencing recommendation. We're asking if the court would consider not imposing the twice weekly, or in the alternate, consider possibly only once weekly of the AA classes. Mr. Ryans does state to me that he continues his enrollment in school. It's my understanding that he's taking 16 credit hours as well as working during this time to earn money. He does have some concerns about both keeping up his schooling with his job if he is attending 2 of those per week. To my understanding, he has been completely compliant on his bond, and this is his first offense of something of this nature. Outside of that request, Your Honor, we would ask the court to adopt probation's recommendation.
Sir, is there anything you want to tell me before I impose sentence?
No, sir. Pretty much as my attorney has stated, I've tried my best to stay compliant with my tether. I have quit alcohol earlier this year in April, and I plan on keeping that track.
Where are you in school?
Washtenaw Community.
What are you going to be when you grow up?
Currently, I'm studying business administration and looking to transfer over to Michigan State with fall 2027 enrollment.
To where?
Michigan State. That's where I'm looking to transfer to for management.
Why? For God's sakes, why?
A lot of people feel like I'm betraying you, Mish, but honestly, I feel like the competitiveness.
That might get worse. Why Why are you going transferring to state?
I feel like the environment is just a little bit better for me. The competitiveness with
Have
U
you
of
ever
M.
been there?
No, I took a tour there back when I was
It's like
17.
you took a tour at 17 and
Yes,
it took
sir.
forever, didn't it? None of the buildings are together. The whole place is like spread out.
Yeah, the entire city is the campus.
Yeah. So you really want to be a Spartan?
Yes, sir.
Hold up, did the judge just roast Michigan State while sentencing? Yes. Yes, she did. Humor like this isn't random, it's a pressure test. She's gauging maturity, honesty, and whether this defendant can handle accountability without unraveling.
Well, we might have to change this sentence. All right, young man. Well, I wish you all of the best, and I'm just teasing with you. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of intensive outpatient treatment, attendance at AA meetings, and abstinence from all intoxicants. The court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It is therefore the sentence of the court that you are placed on 18 months probation. You are to pay $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $540 probation oversight fees. When can you pay that?
Give me about 48 hours, please.
48 hours?
Yes, sir.
Oh, I like you. All right. I'll tell you what, pay it by the 26th, okay?
Here's the legal pivot. This offense could mean jail, but the court chooses rehabilitation instead. Probation isn't mercy, it's surveillance with homework. Slip once, and the backup plan is a jail cell.
Sir.
Has the Spartan ever told me yes, sir? No, he's going to be the first.
I have.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete an intensive outpatient substance abuse program, including all recommended aftercare with status reports to probation. You're to attend one AA meeting per week with monthly verification to probation. You're to provide proof of victims' impact panel attendance to probation. You continue the scram tether an additional 30 days in lieu of 5 days in jail. All order 93 days in jail that is suspended. Thank you.
Thank you.
Thank you, Your Honor.
And sincerely, young man, good luck to you.
I appreciate you. Thank you.
Thank you, Mr. Ryans.
Court does call the case. People versus Brendan Williams.
Hello.
There he is. Assistant Public Defender Natalie Pate on behalf of Mr. Brendan Williams. Sir, can you please state your full name for the court?
Brendan John Williams.
Thank you. Your Honor, today's the day and time set for sentencing. Likewise, I had the opportunity to review both the assessment as well as the recommendation from probation. As to the recommendation, we are respectfully requesting that the court adopt it.
Sir, is there anything Ms. Blair?
Your Honor, Teresa Clare on behalf of probation. I would just like to make the court aware, I did receive Mr. Williams's victims impact panel attendance. Also, so the court is aware, Mr. Williams is starting on probation with me on another matter. This case is not a violation of that case. It happens prior to being.
Got it. All right, Mr. Williams, anything you want to tell me before I impose sentence?
No, thanks.
Okay. Court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of substance abuse and mental health treatment. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court, I'm going to place you on 24 months probation. You're to pay $1,055 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs. I will waive the probation oversight fees. When can you get that paid, young man?
I was wondering if I can work out a payment plan with my probation officer.
Is he already on a payment plan?
Yes, Your Honor.
All right. There'll be a payment plan as directed by probation. Understand that?
Yep.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation.
Compare this sentencing to the last one. Longer probation, stricter programs, but waived fees. Judges tailor punishment like a custom suit, history, attitude, and compliance all matter.
You're to complete a dual diagnosis programming, including all recommended aftercare, with status reports to probation. You're to provide proof of the victim's impact panel attendance to probation, which is completed. I'll order 365 days in jail, credit 42. The balance is suspended. Thank you, sir.
Thank you.
Thanks, Mr. Williams.
Court calls the case, People versus Jason Eckel. Should have heard, I know you're ready. You should have heard what your client said. I don't know why he's not here. It was horrible.
Good morning, Your Honor. Robert Goldman, P81222, here on behalf and alongside Jason Eckel, president of the courtroom this morning. Mr. Eckel, would you please say your full name for the record?
Jason Michael Eckel.
All right, thank you. All right, what are we doing today?
Your Honor, this is a date and time set for a sentencing hearing in this matter. I've had an opportunity to speak with the probation department in this case. Your Honor, a plea was conditioned on Mr. Eckel being admitted into the sobriety court. Mr. Eckel did screen with this court's probation department. Ultimately, on Friday, we were advised that he was not accepted into this court's probation sobriety court program. However, having spoken with Ms. Pilara, it is the understanding of the parties that we would be asking for an adjournment today for purposes of screening with the either 15th District Court or another Washtenaw County District Court for purposes of admission. We do think that Mr. Eckel is a good candidate and can be admitted. So for that reason, we are still seeking admission, as we believe that the ultimate benefit of the program warrants seeking an adjournment at this time.
Okay, correct, Ms. Pilara.
Yes, Your Honor. I did learn on Friday from the 14A sobriety court that he was not accepted. I did speak with counsel and indicated to him that there is 2 other options in the county that he could try to get into their program. I know that Mr. Eckel did have a couple of appointments in those with ours, and they kind of got bumped down the line. This is why it had to be adjourned. My concern is, and speaking with counsel, this plea was taken with the agreement. Is how I read it, that it's kind of contingent upon him participating in the sobriety court. So I would like the court to give this defendant the ability to try to get into one. He did follow through with the screening process. Any delay in that fashion was not on the defendant.
Okay, and I would just indicate, because people have said it different ways, I don't read the plea form that his plea was contingent upon that. What it was is the defendant pled and agreed to enter into the participate in sobriety court. So I don't think it would be a failure of the plea if he's not accepted. Okay, because I think if it were conditioned on that, that would be something different. But I don't read this as saying that he's just agreeing to go in. If they say no, then we've got to figure out something else to do. But all right. November 16th, December 6th, December 7th. What happened with your testing?
Your Honor, having spoken at length with Mr. Eckel regarding it, those 3 dates, if you notice the times specifically for those 3 out of his windows of the day total, they all occurred when Mr. Eckel was at work. Mr. Eckel does work within the engineering maintenance department of a hotel. The windows that he was just slightly delayed from submitting his test within occurred during times where he was engaged physically in his work. He did then go get his device immediately as soon as he was available. I think his tests are all within 10 to 15 or so minutes of that. We have spoken regarding the need to ensure that it is timely, not just submitted at the about the window. Fortunately, the tests all do come back as negative to verify that he was not consuming. We have spoken. He is going to make additional efforts. For the court's understanding too, I think it's important, as Mr. Eckel advised me, within where he works, there's not a locker or a safe storage area where he can keep his device free from access to others or tampering. So he does have to keep his device in his vehicle. So as soon as he completed an assignment he was working on, he'd go get it, albeit as the court can see, about 10 or 15 minutes after the window closed.
Well, no, it's not 10 or 15 minutes. He was half an hour late.
Oh, I'm sorry.
It's okay. Same point. I get it. All right. Just try to make sure you do it within those windows. Okay.
Yes, sir.
The defendant is to seek an alternative sobriety court, either 14B or 15th, which may be available. You live in Ipsy though, so maybe 14B might be a shot he could take.
Yeah, we were going to kind of explore both simultaneously. He does work in Ann Arbor, very close to the 15th District Court. So we were thinking that for review hearings, that might be even more.
This is where people mess up, just a little late on testing. Courts don't measure excuses, they measure patterns. Even when tests are clean, timing violations scream risk. That's why sobriety court access is such a big deal here.
Accommodating with his schedule to ensure he can maintain employment and his obligations under the program. We were going to be speaking with both of the courts to help determine which is the most appropriate.
Okay. I'm just thinking as the new sobriety court came in that, well, anyway, I'm going to adjourn the defendant sentencing to January 28, 2026 at 12 p.m.
Thank you, Your Honor.
Okay. All right. Thank you. Court recalls the case People versus Reginald Sims.
Good morning, Your Honor. Justin Zaid, appearing on behalf of Mr. Sims, present standing to my right. State your name.
Reginald Sims.
Your Honor, date and time set for sentencing. We did have an opportunity to review the report. We believe it to be factually accurate. No additions, corrections, deletions. If I just may allocate on my client's behalf.
Yeah, you may.
I know that based on your tone, I think you know what we need, what else we need to address.
Yeah.
If you would prefer that we address the bond violations first.
Might need to.
Okay.
do that, but
Certainly.
either way, whatever.
Well, we could start with that. That's fine. We were given the bond violation report. I did have an opportunity to review with Mr. Sims. We went one by one, Your Honor. I understand that the court might have concerns. That looks as though there's some type of pattern of disregard for this timing. And what we would submit to the court is that Mr. Sims has been on this device for about 4 months now, about 120 days, testing 3 times a day. I'm no mathematician, but over 360 tests, I believe. What you see in front of you, I believe, is the extent of the late tests. I believe that there are several late tests, some of which are right outside the window, some a little bit delayed. Of course, there's no excuse, no justification for it, but to provide a little bit of context, Mr. Sims works overnights. He works at Ford. And so those tests primarily in the middle of the day would be when he's sleeping. He usually wakes up about 30 minutes before his 6 p.m. shift. And so he found himself having issues. We discussed how of course, we would have been more proactive, brought this issue up prior to getting this bond violation report so that we could find a schedule that would be more conducive with his work schedule, testing schedule, I meant. That being said, I don't think he's had a single